presentation by appreciating you all for taking time off your tight schedule to come and supervise this oral defense. I know it's not within the normal time for the defense, but you have sacrificed your time and your energy to come. So thank you very much. So the thesis is legal risk in international project finance. I'll do the presentation following this order. The aim of the thesis first, then I go to the general introduction, then I will talk about the disposition and the major findings realized during the research. Then I'll conclude with major conclusions and recommendations. So the aim of this research was, first of all, to investigate and analyze the legal risk in international project finance. The main reason for analyzing this legal risk in international project finance came from the necessity to know how and why international project finance could be used to enhance development around the world. Because increasingly, project finance has been used as a tool for infrastructural development. And in my research, I realized that China is one of the nations, one of the countries that are taking a great lead in international project finance. As we are talking now, there are some of these Chinese companies that are executing project finance projects in my country. So the main research question was, or is, what are the main legal risks that need to be addressed in order to create a favorable environment for the execution of internationally financed projects? In order to answer this question, we decided to look into, first of all, to look into what project finance is all about. And we realized that project finance has been difficult to be defined because, one, it is a complex business venture, and two, it is a novelty in the juridical sciences. So it will be easier for us to identify characteristics of international project finance because there is no definition of project finance, there is no generally accepted definition of project finance, and of course there is no legal definition of project finance. So the main characteristic of project finance is that project finance is used for the construction, the operation, and the management of projects in the capital-intensive industry. In this case, there is so much capital that is invested in these projects. And project finance is used to create or to construct mines, tollways, railways, pipelines, dams, ships, in fact, across many spectra of life. And it is used across systems like the build, operate, and transfer, the build, operate, own, and transfer, but it depends on the financial arrangement that is signed between the two parties. Again, in a project finance operation, there are many contracts and many agreements that are signed between the project participants, be they banks, governments, or other multilateral organizations. Again, project finance is a non-recourse or limited recourse debt project. That is, the repayment of the project debt does not depend on the balance sheet of the company, but it depends on the revenue that shall be generated from the management of the project. And most importantly, in a project finance setup, we have a special purpose vehicle which is set up to manage the project. Usually, the special purpose vehicle is incorporated under the domestic laws of the host jurisdiction as a corporation. That is done with the general introduction. So now we're going to look at the disposition and the major findings in the thesis. In chapter 1, we looked at the general picture of project finance.
Sorry for interruption. You are expected to finish the presentation in 10 minutes.
Okay, bro. In chapter 1, we looked at the general picture of project finance, the sources of project finance law, and other risks that are in project finance, like political risk, economic risk, environmental risk, social risk, and others. But we chose to analyze the legal risk because it is our domain of interest, law. And in chapter 2, we looked at the international project finance law and its effectiveness. But we realized that there is no binding international law governing project finance. And one other observation, which is a major one, is that if there were an internationally binding project finance law, the dark hole project in India shouldn't have taken place. So the major finding in chapter 2 is that there is no binding international law regulating project finance. Then in chapter 3, we looked at the effectiveness of both domestic law and its practice within the domestic jurisdiction regulating project finance. In this chapter, we realized that for a domestic jurisdiction to be favorable to project finance, it needs to have a stable and reliable legal system in order to encourage investors to come into the jurisdiction for the project finance to be executed. In this line, we realized that developing countries, developing economies have weak legal systems, and as a result, they face a lot of problems gaining foreign investors coming in for project finance. Then in chapter 4, we analyzed the effects of change of law while a project is already being executed. Here we realized that stabilization clauses are used by project participants to freeze the contracts or the agreements against any change of law. And given the evolution of the world today and globalization, we realized that these stabilization clauses frustrate the evolution of law and its effects in our societies, because we looked mainly at environmental concerns and human rights concerns. They are being defined newly in the world of today, and as a result, with the stabilization clauses, we cannot effectively cause this positive change for the respect of human society, human environment, and human rights. In chapter 5 now, we depart from normal or usual literature, which states that dispute settlement mechanisms are the best ways of protecting our internationally financed projects across borders. This is because in normal literature, in the literature that has been written before now, we see institutions like the International Center for Dispute Resolution, the ICC chambers, as they are presented to us as mechanisms that protect project finance and encourage project finance. But we realize that due to the multiple contracts that are signed in the projects, due to the fact that a project participant could come from a state that is not signatory to the dispute resolution chambers, and due to the fact that there is a lot of pressure from certain governments on their domestic industries to invest outside, we are gradually moving away from the importance of the dispute settlement mechanisms. And that is why we wrote chapter 5. The title of chapter 5 is Dispute Settlement, the unspoken risk in international project finance. This is what we realized. Then we made certain recommendations, 3 major recommendations. The first major recommendation is that we need an international law that can govern project finance, and this law should be binding. It should be in the light of the Rome Statute that governs the state, that governs the international, that creates and governs the International Criminal Court. So that if project participants violate the stated rules, we can be able to prosecute them directly without necessarily seeking the consent of their states. Again, we would like that local courts be empowered to litigate in project finance issues, because when we have the project finance participants coming from various areas of the world, it causes some problems. If we cannot arrive at these general or global resolutions, we can then work towards a regional method of regulating project finance through regional laws, like we have in the OHADA. We have the OHADA law, where certain countries in Africa have decided to be guided by one law. It eases familiarity between the various nations. And the last recommendation is further research. We highly recommend that somebody should study, should research and propose methods that could be used for dispute settlement entirely suited to international project finance, because it is scarce, it is a different type of investment as compared to the other types of investment. And would also like further research to be conducted into the role of the public, the right of the public in defining and designing project finance agreements. Because when they are invested, when such projects are carried out in particular localities, these projects affect the people of the locality, both environmentally and socially. We see violation of human rights and violation of environmental rights. As such, the people may not benefit from the social, cultural, economic, and environmental rights due to the effect of project finance. So that said, we didn't face so much difficulties in doing this research because we had enough time. And the main difficulty we faced, therefore, was the inability to get access from primary sources, from practical people around. We spoke to certain lawyers, and the lawyers declined to talk to us because they feared that they were going to release vital and personal information of their clients. So that was the major difficulty we faced. And at this point, thank you very much for listening to my presentation.